Arvind sir,
Yes, sir.
shall we start now, sir?
Yes, sir.
Dean sir,
Yes, sir.
shall we start?
Mr. Shall we start, sir?
Sure, sir. Sure, sir. Let's start the session, sir.
Very warm welcome to one and all present here. And I welcome you all for this one-day webinar on Now I like to welcome Dr. KPV Savati, Dean of Research and Development and IPR Cell Coordinator to welcome the gathering. Sir, please.
Thank you, sir. Respected CEO and Secretary Dr. R. Manikam, Ratnam Group of Institutions. Respected our Principal Dr. R. Muralidharan. Deans, our IAC Coordinator Dr. C. Kanagaraj. Our IAC Ambassadors, RCAS faculties, and faculties from our mentor-mentee institutions, Michael Job College for Women, Dayananda Science College, Sri Venkateshwara College of Engineering College. A warm good morning to one and all gathered here for this online session. Today, April 26, we are celebrating World's Book and Copyright Day. On celebrating this special day, we, Ratnam College of Arts and Science, Institute Innovation Council, and Indian Patent Rights Cell jointly organizing this online webinar on A to Z of copyright and its registration process. The resource person today is Dr. Prachi Chopra. Our research person is an award-winning IPR expert, founder and director of Intellect, Bastion LLP, for explaining us in detail about the copyrights and its registration process. On behalf of our college and our mentor-mentee institutions, we welcome you, ma'am. Thank you for your presence today and accepting our invitation for this online session. Thank you so much, ma'am. And I hope this session will be a very good session to hear the details of copyright from the IPR expert. Thank you.
Thank you, sir. So,
Thank you so much for the warm welcome. I think I'm trying to turn on my camera, but there is some issue. Still, am I audible to all of you?
Yes, ma'am.
Yeah, ma'am. You are audible, ma'am. You are audible, and also we can see you. Maybe before you start, maybe I think they will introduce you.
Okay, fine.
Aravind, go ahead.
Yes, sir. Yes, sir. So I am extremely honored and privileged to have given the opportunity to address Dr. Prachi Chopra, founder and director of Intellect RCAS IIC and IPR. So Dr. Prachi Chopra is a hardworking which has established a research-made academic and a research advisor, an effective mentor, and an expert in legal matters involving the intellectual property rights and he have completed the bachelor in electrical, electronics, and communication engineering in Maharashtra Dayananda University, and she have completed the MSc in Ambedkar Institute of Advanced Communication Technology and Research. Also, she have completed her doctorate in physical signal and image processing by Indira Gandhi Delhi Technological University for Mumbai. And she have completed an online course on entrepreneurship, emerging economics at Harvard University. And now she is the president of a Delhi Indian Chamber of Commerce and Industry. And also she is a professor in a Bala Business Private Limited, and also an advisor for Vidyas Technology Private Limited, and also she is a YouTuber. And today she is here to address the webinar on we welcome you.
Yeah, thank you so much. So I think I should start now.
Yeah, ma'am. Yeah, ma'am.
Okay. I would just like to share my screen, and it has always been a pleasure to be on service for the institute. Thank you so much for the warm welcome. Yeah, just let me know if you all are able to see my screen.
Yeah, ma'am. Perfect, ma'am.
Okay. So it's A to Z of copyrights and the registration process. So in today's webinar, we will discuss everything about copyrights. Should you have any kind of questions, you can feel free to ask me at the end of the session. I'll be introducing copyrights as a definition, and I'll be, explaining what exactly is the registration process of the same. So my name is Dr. Prachi Chopra, as introduced, and I am founder and director Intellect Bastion, and representing as president Delhi Innovation Council. I request you all to please mute yourself. Yeah. So the outline of the session, outline of the whole presentation will be what exactly is copyright, what do we define copyrights as, and who all should apply for copyrights, and the benefits of having a copyright. What benefits you get when you apply for a copyright? Why should we exactly, why should we apply for a copyright? What benefit it provides? And then different types of copyrights. Copyrights is not just one copyright. We have different types of copyrights for music, for sound, for cinematographic works, for literary works, and for artistic works. There are different types of copyrights. What is the copyright workflow? What exactly is the flow of the process along with the timelines, and how to file an application, which portal can be used to file the application, what are copyright societies, how to license copyrights. Okay, you have registered the copyright, how to license it, how to sell it for your monetary benefits. So these are the different questions which may come in your mind when you go through the whole presentation. So let's just discuss them, all of them, one by one. What is copyright? See, as you can see the image on my screen, it's literary, artistic, musical, dramatic recording. This image clearly explains what is a copyright. A copyright is a law. Copyright law, I think someone has mic not muted. I request you to please mute your voice, mute yourself to avoid any kind of disturbance.
Arvind, please mute all the participants.
Yes,
except the guest. Yeah, it's really disturbing. Thank you.
Okay. So what is a copyright? See, copyright laws grant all the authors. You may be an author. When you are an author, when you write something which is related to literary work, like a book or any kind of novel which you may have written. So if you are an author or an artist or some other type of a creator, then you can protect your literary, artistic, musical, and cinematographic creations, which we usually refer to as a work which you have created through copyrights. Copyrights protects all types of various types of, which I'll be explaining you through examples, that what are the different types of literary, artistic, musical, and cinematographic works. But it protects all of them under one umbrella of copyrights. It protects actually the underlying expression of ideas. So on a topic there may be 10 books, but how you have written that book, how you have written that research paper, maybe if I talk about technical side, how you have written that software code, if I talk about some kind of coding. So the exact expression of ideas, that is protected by copyrights. So the works copyright that copyright covers, they include, but actually not limited to them. These are novels, poems, plays, reference works, newspapers, advertisements, computer programs. This is the one which relates to all the technical departments like institutes, that computer programs, databases. If you have a database which is really, significant in terms of its collection, that database can be protected as copyrights. Films, musical compositions. So if someone has, written some lyrics or sung some music, sung some song, and films, some producer, some director, producer has created a film, that film, choreographic work, a dance which has been created by a choreographer, a painting by an artist, drawings, photographs, sculptures, architectures, even maps and technical drawings, all these works, even engineering drawings, all these works can be protected through copyrights. So this is exactly the main definition of what is copyrights. Now, who all should apply for copyright? Having understood that what is copyright, who all can apply for a copyright? For a literary category, authors, script writers, lyricists, researchers, students being researchers, software engineers, all these people, they are more likely to apply for a copyright. Artistic category mein dramatists, musicians, painters, architect for architectural works, sculpture. So this category of people who relate to artistic works, those people can also apply for the copyright under the category of artistic works. Then photographer, designer, any stage performer, musical composer, film producer, song producer, website owner. If you create some website as a student, as a faculty, if you create some website, you can protect the contents of that website through copyright. I'll explain you how. An app developer, if you create an app, you can protect the contents of that app, interface, user interface of that app, UX, through copyrights. That is the best way of protecting that work. So who all should apply for copyright? There are several other people also. Press and literature industry, music and theoretical productions and operas, motion picture and video based industries. Obviously these all people are somehow linked to the industry of broadcasting and industry of music and sound. So those people who are anyhow linked to those people, like radio television industries, software and database oriented industries, all these people can apply for copyrights for their works. Like visual and graphic art based industries, advertising services, print brochures and advertisement publication, and all these people for their works can apply for a copyright. Now, what benefits of having copyright? What are the benefits? So firstly, when you have a copyright with you, it provides a legal evidence that the work belongs to you. How can you show to some party that this work is yours? You have a monopoly over it. You have a property right, kind of a property right over it. All this can be provided once you have a document that states that, which is legalized by the government, stamped by the seal by the government, and that is copyright certificate. So copyright certificate is a legal evidence that ensures that this work belongs to you. And second is the social and economic development of the country. When you have a monopoly over a work, you always in the back of the mind, you think of commercializing it. And when you think of commercialization, monetization, through a business or through licensing, it somehow indirectly impacts the society. The social and economic development of the country is done through that. Not just economic, but social as well. So, thirdly, the owner has the sole right to get monetary benefits for their work. I just suppose you have maybe written some software code and then you own it by having a copyright over it. You have a copyright registration over that software code. Someone who wants the access to that software code for developing some kind of a website, because you are the owner, he has to purchase that from you. So you get monetary benefits. If that person without your consent uses that, you can always stop that person from doing that. Now this is, equally relevant for any other intellectual property right. Same applies for patents, same applies for industrial designs, same applies for, any other kind of intellectual property like trademarks. But copyrights protect those artistic and literary works, which can be protected by copyrights only. So you have a right, and hence you can get monetary benefits for your work. So it's a good way of generating business for all the literary, dramatic, musical works, broadcasting works, and all such works. Fourthly, right to transfer their copyrights, license copyrights, and earn royalties. Sometimes I have even dealt with such clients who say that we don't have time to create business and get monetary benefits out of our work which we have registered as copyrights, but we just have time to outsource it to someone, to rent it out to some other party. That is called licensing. So if you transfer, it may be like that you completely sell that to someone else for some benefits in return, some monetary good fixed amount in return. Other ways to license it and get monthly rents in return, or get royalties based on per work or per item being sold. Such kind of transfers where you license or sell your copyright and earn a fixed amount in total amount or royalties in return, that can be done by copyrights. This is one of the major benefits. So that's a kind of part-time benefit which you can have through just one good property which you have as a copyright. And last is to prevent the misuse of their original work and legal action if infringement takes place. It's very usual if I talk about US, and it's currently going on, starting in India as well, that when people misuse a property which you hold as a copyright, some other party which you see is misusing the same work which you hold as a copyright without your approval, without giving you payment in return, you can always take a legal action against them. And through those legal proceedings, you are able to ensure that that work has been misused without your consent, and you get injunctive release are given to you in the form of payment. You can not just stop that party, but can avail all the damages in terms of monetary losses through those legal proceedings. So indirectly you earn money through that. So this is something when you have copyright, and then how can you use that for your personal benefits. So these are the benefits of copyrights. Now, format to write copyright notice in a work. You must have usually seen on websites, when any website is created, maybe on any website which you see, there is a small line written on the footer side of the website. It is copyright C, encircle C, year, and by owner's name. So copyright 2008 by Microsoft Corporation. It is very usual to see such kind of statements written on any website, or maybe in the PPTs also sometimes it is seen. So what does that illustrate? That shows, that's a kind of a notice by the owner that this work is by me. So it's a copyright which I hold. Even though you don't apply for a copyright, this statement marks the date from which you are using the work created by you. I want you to understand this line. Even though you don't apply for the copyright, but this small line, marks the date from which you are using your work which you have created, literary, artistic, or whatever work. So when you apply for a copyright, you can, use this date as the date from which you are using all the work. So this type of copyright notice line by default establishes a copyright on your work. then what is the need to apply for a copyright? If such a line is more than sufficient to show that it's your copyright over the globe, then why do we apply for a copyright under the copyright law? The reason is to make it a business. The reason is to make it a business. Unless you have a copyright certificate with you, you cannot, get all the. You cannot apply for any kind of infringement suit in the court that someone is misusing my copyright. So I want to avail some damages in the form of a money, in the form of the loss which I have gone through because of that misuse. Unless you have a proof to show that, you cannot do some actions for the misuse by others. You can just intimate, you can just show others that this is my copyright, but you cannot take actions against that person if that person misuses. For that, you need to have a copyright registered on your name in the form of a certificate. Even if you license or rent out to someone else, as a proof you have to show a copyright certificate. So that is the value of a certificate, as a proof, as a evidence to for any kind of monetary works, any kind of payment related works. You cannot do unless you have the certificate with you as a proof. Now, what is the validity of a copyright? Having understood this complete thing about copyright, that what exactly is this thing, what is the validity? Copyright for literary, dramatic, musical and artistic works, these types of categories for which we have a copyright, it is for 60 years starting from the next day of the death of the author. Suppose, giving my example, at this age I write a book, I commercialize that book on Amazon, people buy that, I earn money, I'm earning money, I get a copyright over it, that book. Now book is all mine and I'm selling it, I'm making business. Now, for how long that copyright in that book can subsist so that I can earn money out of it? That is for 60 years after the death of the author. So once the person who has the copyright over it expires, then after 60 years of that, what I think of is the whole family can get benefit of that book even when the person dies. So this is the value of copyright. It has maximum duration for which the copyright has a longevity. It has a duration for which it is active. Even for patents, when you get a registration now, it has 20 years of active period from the day of filing. Just 20 years. For trademarks, it is 10 years. For industrial designs, it is 10 years. Although that can be renewed. That can be renewed once you apply for renovation. But in case of copyrights, not without paying any renovation fees, you have an active period of 60 years from the death of the author. And in case of cinematography film, suppose there is a producer who created a film, or there is a song which has been created by a composer or a singer who has sung that song. Those people have validity in that copyright from 60 years from the date of publication of that work. Once that work is published, from 60 years from that date, they have that validity of the copyright. So this is the validity of copyright. Now, what are the types? I'll firstly start with musical copyrights, coming to song copyrights, and then I'll come to those copyrights which are more relevant to institutions as students, which are literary and artistic works. Maximum, the most major copyright which is of value to you is literary copyrights, and when you develop some app or website, that is artistic copyrights. So I'll come to that starting from musical copyrights. Now, musical works, what exactly it means? It means a work consisting of music, includes any graphical notations. If some composer or person like that relating to that, he has written some music in the form of some, he has not sung the music, he has not sung, or maybe he has some written the music in the form on a page with some swaras and new harmonies, new rhythms he has written, and he has made a lyrical way of singing that song. So that work, that does not include any words or any action intended to be sung, but there are some swaras, there are some music musical words which are written on a page of paper that ensure that tell the way this music should be sung, that music should be performed through an instrument or by a singer. That musical work which is written over a paper, that can be protected as a musical copyright. Author is the composer. The term which for this will be until 60 years from the beginning of the calendar year next following the year in which the author dies. So when the person dies 60 years from that work can be protected as copyrights. And copyright subsists in arranging music by adding accompaniments and new harmonies, new rhythm, and transcribing it for different musical forces. So if that, suppose you have written some musical composition and that you transcribed into some other language for some other nation, then the copyright subsists in that as well. Secondly, for musical copyrights, what is the difference between musical copyrights and sound recordings then? You can protect sound recordings as a copyrights as well, and you can protect musical copyrights as well. What is the difference? Musical copyrights go somehow in the direction of literary work. Sound recordings is a different thing which you on stage perform as a song. Sound, which comes out of a person who is a singer. Musical work is written, you jot that down on a piece of paper. In a musical work, copyright is not these, tune or the singing, the voice of that person. It's the melody or harmony which you produce it on a printing, writing, or graphical form. I hope you understand this. Something written on a piece of paper as a music is something which goes under the category of literary thing, which is musical, composed work. And something which you sing out of your neck, the sound, the voice, that through a lyrics is something which is sound recording. And that is protected as a recorded copyright. That is different. So when a composer develops a melody which is represented as a sheet music, which may include, there may be Western swaras or some graphical notations. There are so many musical notations which you may not be knowing, but a composer knows. That is registered under music categories. However, when the same melody, same music which is written over a paper and protected as music copyright, if same melody is recorded in CD, which is not written on a piece of paper, but now recorded as on a CD, or maybe some other electronic device, like pen drive, flash drives, or some other medium in which you can store it as a human voice. Now that is registerable under sound category. So this is the main difference. Second is sound copyrights. I have informed you the difference between music and sound copyrights. Now digging more into the details of the sound copyrights. Sound recording means a recording of sound from which, a sound will be produced regardless of the medium on which sound recording is made or the method by which the sound recordings are produced. Regardless that how that sound recording has been produced, regardless that on which medium that sound recording has been produced, CD or electronic device. So the content of that recording, the way that sound has been produced, that can be protected as copyrights. Any song which you see on television is protected by sound copyright. The copyright in that, song is with not even with the singer, but the lyricist who has written that, and even the music composer who has created that. So instrumental music which has been created by the musical copyright, then the lyricist who has written that music, singer who sings that music, all these have partnerships. All these people have some percentage of share, and with which they sign an agreement, an assignment, and register a copyright, and they earn royalties for that for whole life, for 60 years. So this is the value of copyrights, majorly used in broadcasting and sound industry. And the term is 60 years, which starts from the day on which the work has been published. So the difference which you can see in musical copyright and sound recording copyright is, in that case, in case of musical copyright, it is 60 years from the when the person dies, because that relates to something which is literary. So that exists for the whole life. Now, song works which are through CD or electronic device recorded and then shown to people. That for that the copyrights exist for 60 years from the date on which the work has been published, electronically shown, publicized on television. Sound recording, any audio recording will be considered as a work of sound recording. Any audio recording. Suppose you make a video through your mobile, that is a content which can be protected as copyright, as a sound recording copyright. Suppose you make a video of any event happening in your college, so that is also a kind of some singer singing in your on a stage of your college. But obviously the song which you may be copying through your phone, that is already protected by that person now, because it is his song. So that is infringement, that is wrong. So audio recording of a lecture, a song, a dance performance, or any other recording consisting solely of the audio, it should not have any kind of video. You close the video and just record the sound. So that sound audio recording that can be protected as copyrights. Difference between author, owner, and publisher. When you apply for a copyright, there are three major terms which you come under notice of. That is, who is the author of this copyright, who is the owner of this copyright, and who is the publisher of this copyright. See, author is the person. Suppose in case of musical work, I'll say it's producer. So author in case of book is the person who writes the book, right? So author is the person who is involved in the each and every work, each and every content of that work which is applied as a copyright, who is involved, who puts his soul into that work, who knows what is the work exactly. So, like a producer in relation to cinematographic and sound recording work. So, who holds the responsibility and initiative to make the work? Who makes the work? So, one line is who makes the work. That is the author. Who is owner then? Owner is the person who owns the work. So, if you make a book, suppose you write a book, you are an author. Sometimes it may be a case that you are not owner of the book. You sell that book to someone else. If you are selling that book to someone else, that you use it for your own purposes, I'm not selling in terms of selling on Amazon and then giving it to people. I am saying that you transfer your rights to someone else, and now it is not a book written by you. To give you an example, if you have written a software code, it is written by you. You are an author, but then you are not able to make any business and you don't want to use it any further. You have a copyright, you transfer it to someone else who is now generating business through your work. So that is the owner. If you're an employee of some company and you generate some R&D work in that company while being employed in that company, usually those companies get signed an agreement that all the resources, all the work which you create, that will be transferred to us and we will be the owners. That is an employment agreement. So owner is the person who has rights over it. And publisher is the person who makes the work available to public. For a book, you should have a publisher. For a research paper, if you apply it in a journal, there is a publisher involved who gets a copyright transfer certificate signed by you. Usually, when your work is published in a journal paper, you must have seen there is one form which they ask you to sign, which is copyright transfer form. They transfer all the rights to them. People don't know they transfer all the rights to them just for the sake of getting it published in a journal. I therefore never suggest that you should never apply in a journal before you have a copyright over that research paper, because those people all get all the work transferred in your hands. You don't have any kind of monopoly over that work then. But it is a kind of asset which is seen as of value by institutions to have a research paper. Now, another type is cinematographic copyrights. Now, cinematographic films means the works of visual recordings. Till now we have introduced audio working, audio recording, now visual recording. Not just film industry, but any kind of video recording. Suppose your child is dancing and you want see it as a very creative and different kind of dance. You just record that visual and you think it is novel in its sense. It's really amazing and you want to get it protected. Somehow in the back of the mind, these things are done which you when you have some kind of thought in your mind to commercialize it. Otherwise, what's the value of putting so much payments for copyright registration? There should be some objective behind it, either to create a business or maybe in institutions it is used for boosting up the level of the institution as well, to create some tech assets for the institution which can be further transferred, which can be used as a business as well. So both objectives are fulfilled. So the term is 60 years, which starts from the year on which it is first published. So here, once the work is published, 60 years from then, the cinematographic copyrights holds the term. Cinematographic film, any visual recording. It can be any visual recording like videos, short films, movies, animated videos, documentaries, anything. It comes under this. And it even any kind of recording of music, moving images. If you have moving images like photographs, stills, drawings, animated content, all that is also considered as cinematographic film. Video game recordings, animations of moving images, these are also cinematographic recordings. So it also includes choreographic work, dance performances, classroom lectures, public delivery of lectures. These works are also considered as cinema. Any kind of video work, any kind of audio work is sound recording, any kind of video work is cinematographic recording. So next I'll come to literary copyrights, which is important if you want to protect as an institution any kind of software code or some book or some research paper. Research papers, books, software codes, and even databases, these are also with institutions. So specifically talking about institutions and universities, literary copyrights is of much more value. A literary work is something which is intended to afford either information or instruction in the form of literary enjoyment. So literary work it can be textbooks. If some brochure is created, that brochure is a kind of literary work. Any poem, any magazine, any catalog, any letters, any novels, dissertation, PhD thesis. Your PhD thesis comes under the realm of literary copyrights. Lyrics of a song written as lyrics. So all these things are protected as literary copyrights. And one of the major categories which is of literary copyrights is software codes. I'll come to that, because that is somewhat a little bit different, but yes, it's a literary copyright. Term is until 60 years once the person expires. So if you are of 50 age, it starts then, and suppose a person expires at the age of 90, it will be 60 years from the age of 90. So total is 60 plus 40, 100 years. You have a validity for that literary copyright. What is the difference between a dramatic work and literary work? So dramatic work, don't get it confused by cinematographic work or any kind of musical or sound recording work. What I am telling in terms of dramatic work is, suppose you write a script. You want to create a movie as a director or a producer, but you have to write a script. Now script is a literary work. Script is a literary work. So that literary work, when you when you have a performance of play, you have to perform a play. It includes some choreographic work, some recitation. You have to jot that script down on a piece of paper. So that kind of literary work is dramatic work, which is also considered as literary work. Any scripts which you write as a piece of some movie or some other show or some stage performance, that is also literary work. What is artistic copyright? What are artistic copyrights? So right now I'm informing what are the kinds of works which come under that, and then we will see how we can register that. So what exactly are artistic copyrights? Copyrights on painting. Suppose you have created a really good rangoli as a performance on your on a day rangoli day competition of your in your institution. Such a creative rangoli, that's a painting or something, sculpture, some architecture, the architecture of your institution, how it has been created, the whole building, the drawings, maybe if some engineering drawing has been created, some maps, some charts, some plans, some photograph, anything which has relevance in terms of its picturization, that can be protected as artistic copyrights. And the term is again 60 years from when the person dies. See, there is a big confusion amongst people that how to differentiate between an artistic copyright and design registration. Design is also one of the categories, a different type of intellectual property which is used to protect artistic works. Especially suppose if I talk about a mobile. Now this mobile, what is the inner technology behind it? Now that can be protected as patents. What is the inner technology with this mobile phone, how it works? The user interface, how the application tabs look like, that can be protected. You know, user interface, how it looks like, how you connect with that mobile. So that kind of user interface can be protected as not just by copyrights because it is an artistic work, but also as a design. Depends upon your intent. That's why people come to a legal or IP advisor, that how can we protect this work? Depends upon your intent behind that. So if you are more intended towards commercialization as a business and you want to protect the whole function of the design, it can be protected as designs. But if the main aim is to protect how you have designed that UX, not just commercialization, but how you have designed, then that can be protected as copyrights. So there is a law which I'll just state, that copyright shall not subsist under this act in any design which is registered under Designs Act. Suppose you protect any artistic work under the category of designs as an IP, you don't hold any right to protect it as a copyright as well. This is one of the laws of Indian Copyright Act. Secondly, copyright in any design which is capable of being registered under Design Act. Suppose you have a design, it is equally capable of being registered as a design or as a copyright. So if you register, but which has not been registered as capable of being registered as a design but has not been registered, it shall cease as soon as any article to which the design has been applied has been reproduced more than 50 times by an industrial design by the owner of the copyright with his license by any other person. So these are some of the legal works which actually are introduced or informed to the client when on case-to-case basis. But yes, this is just a confusion between designs and artistic copyrights, that where to protect one and where to protect the other. So next, there is a big confusion in the market that how to protect websites, how to protect apps, how to protect software codes, under which IP they come. Some people think it can be protected as a patent. Some people think it can be protected as a design. Some people think it can be protected as a copyright only. So definitely in terms of softwares, it's a big confusion. So see, computer software or program, if you just have a coding, maybe in Java, maybe in C, C++, any language, if you have just the coding written and no functionality, not by the virtue of functionality, but just the coding, the way that coding has been written, the coding is protected as copyrights. That coding, and for the purpose of protection, what you provide, your source code and object code. So once you provide a source code and object code, that coding can be protected as a copyright. But to protect the functionality, how that code has been used in some hardware form or in some interface to provide a functionality which is of use for the society as an application, the function to which it has been dumped in the form of an hardware, that is protected as patents. There should be some tangible thing involved along with the code, or there must be some technical utility involved along with the code, and not just the code which is just a basic code written even on maths work. You can find that it should have some kind of definite purpose, and it should be in the form of a tangible product, or some having something, having not just a code, but it should have some functionality linked to it, introduced in the form of tangible product as well sometimes. So that can be protected as patents, which is a different IP altogether. So software codes, and it also includes computer programs, tables and compilations, and computer databases as well. So this is the confusion which is regarding software codes, protected as literary work. Second is app. Suppose you create an application, mobile application. Usually students create that. Any application is created, which is a self-contained computer program. So it is designed to perform a specific task. You perform a specific task, and majorly students create an application for some works, different types of works, and they see it as a novel work created by them, and they are happy to see that. How to protect that? So the coding part of that application, the code behind that application, that is protected as copyrights, and the artistic contents of that application, the UX of that application, user interface, that is protected as again copyrights, but artistic copyrights. The UX is protected as artistic copyrights. The software code is protected as literary copyright. So these are two different copyrights which protect two different things of one application. Two copyrights protect an application. So app usually has a primarily dynamic content, and it is designed for user interaction. So any directly or indirectly in a computer, handheld, electronic device. So that's why I have written that the literary thing can be protected as the literary thing protects the coding, and the artistic copyright protects the user interface of that app. And similar is the case of a website. What is the website? You have a website in which you have multiple pages which are hosted by a server. So there is not just one page, there are multiple pages. And components of a website can be different in different form. There in a website, you can check if someone has a website, there may be text, tables, computer programs, compilations, so computer databases, photographs, paintings, multiple types of things are on a same single website. Sound recordings, sometimes you upload a video and publish it on your website. Sometimes you upload an audio and publish it on your website. There may be so many things. So website as a whole cannot be protected as a copyright. The different components of a website, if your website has some kind of audio versions, those are protected as that song copyright. If it has some video versions, those are protected as cinematographic copyright. If you have some literary content, that is protected as literary copyright. If you have coding behind, obviously if there is a what is the coding behind the website, that is protected as again literary software coding copyright. If you have some images on that website which you want to protect, that is protected by artistic copyright. Depends upon your need, that what is your need behind that copyright. So this is as regards websites, apps, and software codes. Coming to the copyright registration process, it's a process which is followed by initiating filing. You pay a prescribed fees and file the application. You get a diary number, and within 13 days, there is a waiting period. There is a waiting period once you file, so that if there are any oppositions, people can file oppositions. If there are any objections, then those objections are notified to you. You file a reply. You may go through a hearing if registrar asks for that, and then your copyright is granted or not granted. If there is no objection, it straight away goes up for the scrutinization by the examiner, and the application is granted or not granted. Now, if there is any kind of discrepancy, if it is found, a discrepancy is issued to the applicant. Discrepancy, any kind of problem found with the contents of the copyright. Applicant replies to it. Hearing may or may not be there, and then the registration process is approved or not approved. What majorly is the process is, once you file and after going through the registration and a 30 days notice period, if there is no objection, you straight away get a copyright registered. If there is the objection, which in 90% cases usually come, because there are some objections and that is a part of duty of the Copyright Office, then you reply back to those objections. There may or may not be a case of hearing, and further lastly, the copyright is accepted or rejected because it is under the discretion of the Copyright Department. Now, once the copyright is registered, there may be a cases of opposition as well. If the registration is done, sometimes some parties, which is a different party, may say that how this copyright has been registered, it is already with us. This is something wrong. Those are opposition proceedings, normally not seen in the part for institutions and universities, but in corporates it is seen because those their intents of creating a business are more. They have so many monetary benefits involved in having a copyright registered. So, but if I talk about institutions and universities, their intent is different. Not to create a business, but the intent is to get their institution or their level at a higher level, at a different level, to create value of their institution. Then how to file an application for copyright? Straight away the link is given. There is a government portal. You can go and register there. But people usually don't do this by themselves because there are so many acts and laws involved, and as a novice person, when we go through it, we are not able to understand the process. But as an applicant, you are eligible to apply. But as a novice person, sometimes rejections, I have gone through some clients who say our copyright was registered, was not registered, it was rejected. And then we come to, notify them on checking the case that this is the reason why it was rejected, because they don't know the process. They don't know how to respond back. They don't know what documents are to be filed. They don't know the whole proceedings. So that's why, that's the reason. So because this is something which we have gained from an experience of so many years, which is understandable. Now, documents required for copyright filing. No objection certificate. If you have a research paper and you have published it, your publisher has to give a no objection certificate. If you don't have a no objection certificate from the publisher, you cannot file a research paper as a copyright. So no objection certificate from anyone who is involved in the copyright. Suppose in your research paper, you write the institution's name. So you have to get a no objection certificate from your institution that you are writing your name, the institution's name, and the institution doesn't have any objection on a copyright being registered on your name. So no objection certificate from any person who of whose image, maybe if you have an image of an film industry person who is a well-known public figure in your work, then you have to get a no objection certificate from that person that you are using his or her image, and that is not for any other purpose but just for getting a copyright. So all these persons who are involved in your work, they have to provide you no objection certificate in a proper format. Then licensing affidavits, power of attorney, which is obligatory, which is very important when you get it through some legal representative or some attorney. Copies of your work, name, address, nationality, and if you have some copyright which you want to register in the form of a goods or service, trademark certificate, which is on a prescribed payment, and various other documents which may be linked to it. Government fees, if I talk about, for literary, dramatic, musical, artistic works, it's very nominal fees, which is INR 500 per work. And if that literary, dramatical, musical, artistic work is linked to some good or service, then it is 2,000 per work. That means if it is related to some commercial aspects which are to be sold, then it is 2,000 per work. Difference lies between it if it is for non-commercial purpose or commercial purpose. If it is for non-commercial purpose, it is 500 per work. If it is for commercial purposes, it is 2,000 per work. Then copyright filing of cinematographic film, it is 5,000 per work. And for sound recording, it is 2,000 per work. So there are some copyright societies. Once you have a copyright registered, You can license your work with the help of these copyright societies. These are government authorized societies. They can help you for the commercialization or licensing of your copyrights. Some examples are Indian Performing Rights Society, which is for literary works, Indian Performing Rights Society Limited, IPRS, for literary works. To commercialize your photocopying works or reprographic works, it is Indian Reprographic Rights Organization, IRRO. You can check the websites. For singers to commercialize their work, suppose you have sung a music and you want to sell it out to public and earn benefits, then it is Indian Singers Right Association, ISRA. So this is the ways you can license your copyrights through these copyright societies. This is something which is done after you have, got the copyright registered and you have a certificate. So other ways are to do it through by private basis, through on your own, through marketing agencies. Suppose Amazon has a way of uploading a book written by you, and as a personal way of commercialization, you can earn royalties for the copyrights you have. So these are the ways. And there is this last PPT I would just like to introduce to inform you the works which are not considered infringement of copyright. If you have a copyright and someone uses your copyright for these enlisted purposes, you cannot blame that person for misusing your copyrights, and you cannot file a case against that person. And these reasons which are eligible to be used to be for any kind of copyright, even though it is registered by someone else can use your registered copyright for private use along with research. So if someone has protected his or her research through maybe patents or copyrights or anything like that, privately any organization or institution or university can use it for research, but not for commercial purposes. For all the purposes which are not commercial, it can be used. For review or criticism, newspapers can use it, media can use it for the reviewing and reporting. It can be used by print media. It can be used in photographs. It can be used in a judicial proceedings for some reporting purposes. And you can use your musical, literary, dramatic, artistic work for to be prepared by the Secretariat of the Legislature. So all different works which relate to use for non-commercial purposes. So making just for the sake of educational institutions, if you want to teach your students, if you want to use it, for public reading, if you want to use it for, making your life better in a non-commercial way, you can use it. But for commercial purposes, you always have to take a consent from that registered person, pay him or her royalties if that person desires, and then only you can use it. So I hope I have clarified everything related to copyrights. If you still have any questions, you can in another 5 minutes or 10 minutes ask those questions. Thank you so much.
Thank you, ma'am. Thank you for the presentation. Dear participants, the session is open for discussion. So if you're having any questions, you can enable your mic and you can ask your questions, or even you can post your questions in the chat box. Dear participants, the session is open for discussion. If you have any questions, you can enable your mic, ask, or you can post your question in the chat box.
Good afternoon, ma'am.
Yes, please.
This is Dr. Kanaraj, head in biotechnology.
Yes, sir.
Ma'am, I need on clarification. So recently, I had submitted in my plant species, so in National Biodiversity Authority, so NBA. Yeah. So they will accept my application and give approval for applying the IPR. Okay. So what I should do in next level?
Okay,
So I
this
got
is
approval
something.
from NBA, but I didn't file the patent. So they are recommend for the filing of patent.
This is regarding what kind of invention? What kind of
This is
invention
the
is this?
herbal plant compound.
Yeah, so for that you have to approach NBA because it requires the bio approval from those authorities. But you should have some attorney link with you, which can who can register it as a plant category. If you want to protect that herbal category, is this something which is a plant which has been created by you? If you think that which is it's a plant or herbal category which is created by you, and you are well. You know, you can say that it is something novel and it is not something which is just a traditional knowledge which India owns and you have just recreated it. You have something which is something which is novel in the sense. Okay, so then you should get it registered under the Plants Act. It is not protected by patents. That is a confusion, that plants and animals can be protected as patents. It can be done in different countries, but in India, it cannot be protected as patents, plants and animals. To protect plants and animals, you have to protect it under a Plants and Animals Act, which is different from patents. I can tell you the website as well. I need to check that Plants and Animals Act website. If you can check it on Google, no, you will be able to check that. So get it registered there through attorney or by yourself if you are able to do that, because it involves so many rules and acts. NDA is definitely required. That is a good step taken by you. And at the back of the mind, you must be having some motive behind it. So registration is important. Otherwise, without registration, what is the value of getting it approved by NBA? I hope you understand. If you have a registration certificate with you, you can use it for your own personal benefits and even to show the institution that you have done this work. So you have to get it registered.
Yeah, I got a registration certificate. Huh? Yeah, I got a certificate.
You have got the registration certificate?
Yes, from NBA.
From NBA, na? Now you have to get it protected.
Yeah.
Get it protected through under the category of Plants and Animals Act. There are so many IP forms. One is patents, trademarks, copyrights, designs, and Plants and Animals Act is a different type of IP. So you have to protect your work under that category and get a certificate that this is your work.
Okay. Sure.
Okay.
Thank you.
Dear participants, if you have any questions, you can enable your mic and ask questions. I think there is no more questions. Thank you, ma'am. Thank you for clarifying all this.
Most welcome.
Now let us have a formal vote of thanks. So it is such an honor for me to propose the vote of thanks. So on behalf of Rathinam College of Arts and Science, and I would like to express my gratitude to our honorable resource person, Dr. Prachi Chopra, founder and director of Intellect Bastion LLP, to take out time from her busy schedule to grace the event. Thank you for inspiring and encouraging us with your words, ma'am. Thank you, ma'am. And I would like to thank our Secretary and CEO, Dr. R. Manikam, sir, for his encouragement and support. Thank you, sir. And I special thanks to our beloved principal, Dr. R. Muralidharan, sir, for providing his immense support. Thank you, sir. And I heartily thank our convener of the program, Dr. KPV Sabaris, Dean of Research and IPR Cell Coordinator, for organizing this wonderful event. Thank you, sir. And I would like to thank our IIC convener, Dr. Sri Kanagaraj, sir, for his support. Thank you, sir. And last but not least, I thank all the innovation ambassadors, IIC coordinators, and Menti institution and Menti institution IIC coordinators and participants for their support and active participation. So once again, thank you all for making this as a great success. Thank you.
Thank you, sir. Thank you, ma'am.
Thank you so much. Okay, so I'm leaving. Thank you.
Thank you.
Yes, ma'am. Thank you.